Now, we're going to be starting a Q&A soon with Bernard and Witness J. If you've got any questions for either of them, make sure and enter it in the Q&A section of the screen. I have had a couple of questions come through, and actually I should mention that Witness J, we say that he was incarcerated on secret charges. He now is lucky enough to have Robert Richter QC acting for him. Robert, in my opinion, is probably the best criminal advocate in this country. And Robert texted to say that he's acting for Witness J and still does not know, despite trying, he does not know what Witness J was prosecuted for, what offence he was convicted of. Now, how can that be? How can that be in this country? We have such high ideals about what this country is about. We really ought to know. We really ought to know things like that. It should not be possible for a person to be charged secretly, so secretly that even after they're released, no one is allowed to know what charge they were convicted on. Now, before we start the Q&A, as I mentioned before, for all of you who believe in human rights and the right to free speech, this is, although not a fundraising event, is an event at which we can raise funds. And you might consider becoming a human rights or a civil rights defender. This is the accolade attained by people who become regular monthly givers to Liberty Victoria. It's a program that helps sustain the day-to-day activities of Liberty, and it helps make sure that we are properly resourced to be able to take on every human rights challenge which is necessary. So if you're able to give even $10 a month, I would respectfully ask that you consider tonight not leaving without joining others who are willing to support Liberty every month. Obviously, if you can afford more than $10 a month, that'd be great. But bear in mind that every amount that Liberty receives makes a big difference, and every amount is a strike in the battle to protect our human rights. So I hope I can count on you. Now, very shortly, we are about to start with the Q&A for Bernard and Witness J. And so far as Witness J is concerned, that will be through Hugh Wetherall, who just read Witness J's statement. And so if there is a bit of lumpiness in the question and answer process, just take it. Now, can I start with a question for you, Bernard? Assuming the case against you fails, what will the greatest impact of the case have been?
Myself? Well, it's just, as you know, Julian, if you take a long holiday as a barrister, it's very hard for briefs to come back. It's very difficult. And they say when you go into a Royal Commissioner, I've done a few more than year-long matters, and you find there's very little afterwards sometimes. People think you're preoccupied still with the commission or the inquest or the inquiry. So my practice has been ruined. My retirement, comfortable, probably was going to be a fairly sparse retirement anyway, but it's now not a comfortable prospect. And I have children and grandchildren and children in school and university with the name Collaery. It's not a nice thing. I mean, I hope they're proud of their grandfather, but it's not nice. And particularly the primary age, children don't really understand. They just hear jail and trial. So I think just the injustice of it, there's just such awful karma for me to be about to go into the dock of the court where I've spent my career. It's Shakespearean. It's, well, it's pretty tragic, really. It's wrecked everything. I don't think I ever could have imagined that this appointment, this man coming in who I couldn't turn away, could not turn away, this man coming in to see me, a man whose operational background I knew nothing of in terms of anything relevant. But I'm never going to walk out on seeking justice. I know where you come from too, Julian. So that's just where we come from as lawyers. And we have to lump it, and I'm lumping it at the moment.
Thank you. I should say, I misspoke before. I said that Robert Richter acts for witness J. He in fact acts for witness K. How bizarre that he's still not able to find out what he did. Perhaps he learns more by tuning in tonight than by asking the authorities. And I did have a question for witness J, which is, what's been the greatest difficulty you've faced since you left prison? Sorry, we'll just have to wait for Hugh to learn what he's to say in answer to that.
Hi everyone, sorry, just getting information from Jay. So his most concerning point in terms of getting out of incarceration is actually having two identities, and that's been the hardest part, in that he has his witness J identity, and then he also has his personal one, and the fact that he can't connect the two within the crippling orders of the Canberra justice system, unfortunately means that is the hardest part about going about his daily business, that you can't disclose things between friends, partners, that he was once whoever this person is, that he's now witness J, and vice versa. So that's the hardest part, yeah, hopefully.
Okay. Well, now, I'm told because of the nature of this event, I'm going to get questions from people out there, and they will be sent through to me, and then I'll get to ask you. So it's kind of tricky. But, so forgive me if I'm reading from my phone. Now, I think, Bernard, this is a question for you. Has witness K actually pleaded guilty, or simply given notice that he may do once proceedings are commenced?
Well, as you would have done many, many times in your career, you sometimes intimate to a court that, subject to the police statement of facts and the circumstances and any victim impact statement, etc., subject to discussions and negotiations with the prosecution, my client is minded to plead guilty. That's the circumstance, as I understand it. I haven't been present in court, but there's been an intimation that Kay is considering pleading guilty. It's an intimation, it's not a plea. He has not pleaded guilty to anything.
Now, there was a decision by the judge hearing the matter on the application of the Attorney General, Christian Porter, to suppress evidence. Now, is that the ruling which has been appealed? Or has that ruling been appealed?
His Honour brought down a multi-page reasons for judgment. The judgment, in short, was that the core of my trial would be in secret. We were reading that judgment a few minutes later in the room adjoining the court, and Mr. Porter's officers came into the room and asked for the judgment back because they were of the view that His Honour shouldn't have produced it on his own laptop, and the judgment contained matters of national security significance. And so I never got to read it. There is now produced, extraordinarily, I don't think we've ever seen it ourselves in our lifetime. The judge there was another hearing on another day. The attorney's officers I want to make clear the Commonwealth Director of Public Prosecution representatives have no play in most of this, next to nothing. They're on the sidelines. This is Attorney General Porter having his officers in court. I'll come back to that in a moment, but the judge was asked to redact various things by Mr. Porter's office, and the eventual outcome is that there is a unredacted matter, that judgment that's secret, that the media and Australians can't read, and there's a redacted one. So there it is. In respect of the role of the Commonwealth Director of Public Prosecutions, Julian and I, as Attorney General in the ACT, was very keen to create the Office of DPP in the ACT, and that came in. I think the bill was drafted, or the Act was passed, and then my successor, Attorney General, joined it. We all know that after the Guildford Six in the UK, the Independent Director of Public Prosecutions was established in the UK. It followed in 1985 for the federal government here in Australia. So why, in these more than 35 court appearances, are the proceedings dominated by the Attorney General, a politicians, his representatives, and why does the Commonwealth Director of Public Prosecutors have so little to say? What we're seeing is another bulwark of democracy eroded as well.
Now, your trial involves some criminal actions by some politicians. And generally speaking about the law, when it comes to national security legislation and criminal acts, what recourse is available for keeping politicians to account in the intelligence space? What mechanisms would you consider adding to our current landscape, given that Australia's got more anti-terror legislation than any other Western country, so far as I'm aware?
We've got to repeal this legislation. It was the legislation is being used at the moment against myself and Witness K as a fig leaf to cover the coalition's shame. I doubt that there'd be more than 1 or 2% of Australians who believe that this is a fair go, what's happening. The fig leaf is to use laws that were introduced to tighten up on national security post 9/11. If you read the Hansard debates, there'd been a problem in a trial in Canberra. That has been suggested to have been the reason for it. There were other reasons, but the fast passage of the bill was pushed on the opposition in the context of terrorism and the steps we had to take to fight terrorism, that terrorists would use the court to prolicize, that they'd find out the identity of Secret Service agents, and they'd learn techniques and the rest. I mean, what possibly could relate to national security in a hearing of the nature of mine, where we have none of those issues in contest whatsoever? We simply want, I simply want, and Kay simply wants, a finding of unlawful conduct and what flows from that. Because Julian, you know Lungi, as the High Court decision in Lungi is better than I do probably. And of course, the public, the Australian public, are entitled to know about matters involving the parliamentary executive if it would concern and be proper for Australians to know. And the wave of disgust in relation to this matter sweeping Australia, particularly the legal profession, suggests that it is, in the terms of the High Court, a matter Australians would want to know about and a matter of concern to them.
There's another question which I think you may be able to deal with. It's when will we be able to read what Justice Mossop said on the suppression of evidence?
I don't know, I haven't got it yet. You do know that the orders against me are that I can only talk to my lawyers in Sydney only in a room that they've surveyed, cleared and checked. And I need to go to Sydney to read documents. There is another safe somewhere in Canberra where a very, very decent colleague of mine, a member of the bar, is again giving me pro bono support. I can go to his chambers if he's there, and he's a very busy barrister, and read documents. So I haven't had the opportunity yet to read the full judgment. It was taken away from me just afterwards. We've got an extension of our time to appeal because of this delay, and we'll almost certainly be appealing because we need a decision as to what is the proper place of a neither confirm nor deny claim in our courts of law in this country. Are we going to go that far? That I can be put to trial for something I think as Ian Cunliffe is reported, who wrote in Sydney Morning Herald, perhaps The Age yesterday, can I be put to trial for something that didn't happen or may have happened, didn't happen? I mean, that's the absurdity of it.
It's interesting that you mentioned Ian Cunliffe because he has said Australia has never faced such a challenge to its status as a fair democratic country. We must fight and never surrender. I stand ready to do what I properly can do to fight the authoritarians. Now, that's something, Hugh, which I'd like to get a comment from Jay about. But since that will take a little bit of time, Bernard, would you like to chip in on that?
Look, after the raid on my chambers, the Hallowed Trinity College in Cambridge effectively offered asylum to my team, myself. I got this wholly fraudulent title there as Senior Academic Visitor. And that was because their second most senior fellow had been described in The Hague as complicit in the breaches of Australia's national security. That was an extraordinary comment to have been made by Australia, and particularly before an international court, of whom three of my leaders, Sir Elihu Lauterpach's students, were on. Even the Russian judge leaned forward in shock when Sir Elihu Lauterpach stood up and said, well, I haven't got much to say today because the other side have seized our brief. I mean, Australia is diminished. It's diminished in the eyes of our colleagues, Julian in the United Kingdom. You don't lightly imply that the second most senior member of the bar in the United Kingdom is complicit in law-breaking, particularly a member of the bar, Distinguished Knight of the Realm, a wonderful person, and Sir Elihu Lauterpach. And I was, all of my team, deeply ashamed. In fact, when we went back into our robing room, some of my team wept. We were so deeply ashamed of our country, deeply, deeply ashamed. And we're insulated to some extent, particularly with COVID-19, from the reactions abroad. But I wasn't surprised when today it was announced that Covictus has declared Australia now not a free democracy, but a narrow democracy. This is awful. This is, we must fix this. It's not just my trial. My trial is no longer whether I gave a secret away to a foreign power. I mean, as if this trial is about whether we have rule of law in this country, whether we are a democratic country, and whether our courts can stand up to the executive, and whether provisions of law that say a judge of our court must give the greatest weight to the opinion of a young federal attorney general. Now, I'm touched by the Second World War, won't go into that, but I was looking at the National Security Act 1939 the other evening. Do you know, with a barbarous and bestial aggressor threatening Australia in 1939, and after the sack of Nanking, the massacre in Nanking, we knew what could be faced if the Japanese invasion reached our shores. Not even in that emergency, facing such a bestial prospect, did our Parliament deny judges the right to close a court. Section 8 of the National Security Act 1939, passed by Robert Menzies, Evatt, Curtin, Chifley, all those members of Parliament, Beazley, that left the power to close a court in national security trials to the judges. How is it that we've gone away from what we didn't do facing an invasion? It just shows the excess of executive power in this country and how it must be reined back. It has to be reined back.
Well, that leads naturally to a question which has come from a couple of quarters. How can we help you and Witness J and Witness K?
Those black letter laws can potentially see me in jail if I don't get an open hearing. It's not me who should be on trial. We need to watch ourselves, Julian, as you know. It's not me who should be on trial. It's not me.
I agree completely.
It's
and I hope that people taking part understand why that is the case. So, has a trial date been fixed for your hearing yet?
no. We will most certainly appeal the decision by a single judge to allow me to be tried on a neither confirm nor deny basis in secret. And thus, the defence I wish to bring, which would wholly implicate others, will not be heard in public.
I don't know if that deals with this question, but do the rules of legal professional privilege still apply to your trial?
Yes, indeed. Yes. Yes, I suppose so, but do you know what I'm dying to do, Julian? I would love to go and talk to Penny Wong. I'd love to go and talk to Mark Dreyfus, unforbidden. Yet I read in the papers that Attorney General Porter and officers of the Attorney General's Department have been briefing Penny Wong and Mark Dreyfus. Now, those Section 22 orders, that are the secrecy orders that we can't talk about anything, are imposed on me, my lawyers, my colleagues, the community, everyone. The court staff were warned. The judge, indeed, I've sat in a court and heard an attorney warn a judge that these penalties were applicable from the bench down. Now, what are they doing briefing Mrs. Dreyfus and Wong when I can't?
Yeah, fair question. There's a question here for Witness J. I don't know how long it'll take you to get it through to him, Hugh. The question is, do you ever fear for your safety from possible adverse action from your former employer?
Yeah, so Jay and I spoke about this, and I've got a fairly consistent response. And essentially, he doesn't fear his former employer. The largest part of it, he feels 99.9% confident with his former employer and being safe from them. It's actually more the foreign actors and the foreign intelligence services that he's more afraid of, and that has a twofold effect. There's the physical effect of that foreign intelligence organisations and their agents are very good at getting rid of people, and obviously with what's been in the media and that sort of thing, there is interest around that. But the other point that Jay's more concerned about is actually foreign actors trying to influence him and act against Australia. Now, he makes assurances that that would never happen, and that Australia is loyal to Australia. However, these people do have big sticks and carrots, and I'm sure that they would be very intimidating, and that is a genuine concern of Jay, is that these people would try to influence him against his country.
Julian, could I come in and comment also? I mean, the mere fact that there is a witness K should tell the Australian people that there is morality and integrity in that agency. That tells you that there are courageous, decent people in the service of our country. I'm a great supporter of our intelligence services. They're necessary. It's their proper management. The maintenance of their morale is vital, and we have to be even-handed and decent. You do recall there was a major Soviet defector in 1992. Following that major defection, the United States and Britain came to Canberra during Paul Keating's prime ministership, and close to, I don't want to be specific, but close to 10 intelligence officers in an agency were quickly retired. These are issues that have to be dealt with evenly. Why is Kay being put through this, and why were up to 10 officials retired after a major defection in 1992? This is not secret, it's reasonably well known, but it doesn't seem to be even-handed to pursuit of Kay when persons who were quickly retired, I've got to watch myself, swiftly retired following a major Soviet defection. So we lack proper oversight of our agencies at a parliamentary level. The Intelligence Committee of Parliament, I'm abbreviating its name, has no role on operational matters, no role at all. And I think the vast majority of Australians think that the matter that I'm associated with relates to improper conduct, of no gain to Australia, certainly no economic gain, loss, certainly nothing to do with defence, because we need to keep Timor as an unsinkable aircraft carrier on our trade routes, and absolutely nothing to do with foreign relations to keep that country uptight as it had been for 10 years about its treaties, could not be consistent with developing effective foreign relations. On every one of the three planks upon which the Intelligence Services Act authorised the agency to act, there was a gross failure. It was a most stupid, unintelligent operation that should never have happened, and it should have been allowed to go away quietly. And Kay was prepared not to press for a finding of unlawful conduct, with presumably the compensation that should follow. We won't go into the constructive dismissal aspects of it all, but he's been brought alive by this young attorney. Why? Why? What is the reason why Australia's been dragged down again in our region? Why? Another bad decision?
Could be. Now, Hugh, can I give you another question for Jay? He says, I've recently read Witness Jay's book, Here There Are Dragons, which you and I both read. I'd recommend to anyone wishing to hear more about his story. I'd love to hear more about your story. Maybe we can share a chat over Dr. Pepper one day. I frankly don't know quite what that question means, but there it is. And there's also a question whether an ICAC would help the schnozzle.
Julian, I have an answer from Jay, actually. And Jay's currently writing a book, Roman a Clef, which is a fictional story, a fictional novel about a spy. So stay tuned for that. But maybe one day we'll see Jay's story. We don't know.
Well, that raises a question for me. Bernard, are you going to write a book?
Well, I wrote a book.
Oh, yeah, of course, the one that was released just recently. But
Troubled Water, Melbourne Uni Press. But you do know that the manuscript was out, and then I received letters saying if I revealed secrets, I could face 10 years jail. We went ahead, and I got the summonses. There's an issue there, but good on Melbourne Uni Press having the courage to go ahead with it. But will I write a book that covers the matters that have been quenched and made secret? I think there should be public trials. The irony is there should be public trials of the real malefactors in this matter, and those trials would enable many others to write a pretty good book about a day of reckoning.
yes. Well, I hope Jack Waterford would be there every day of the hearing. Has an approach been made to the Law Council of Australia for help? The matter threatens the entire profession. I believe law societies and bars should get involved.
Yes, Pauline Wright, who's the current, as you know, Julian, head of the Law Council, rang me the other day. She is engaged. She's looking into the issues prudently and carefully. My difficulty is in being able to brief anyone but my cleared and approved lawyers. I mean, it's common knowledge that Kay was approved to see me, that he had a letter from the Inspector General saying he could take, if he wanted, private legal proceedings, and so on and so forth. But the essence of it is that our profession is under dire threat.
Mm.
And
it's only members of our profession like you who can actually help save it.
Well, and that's why, in some respects, there can't be a cowardly retreat now and leave those secrecy orders on me. I really need to have a full public hearing. We've agreed from the very beginning there's no issues of national security need to be raised in my trial. My defence is clear. It should be obvious to everyone this evening whether you can be prosecuted. Is it a crime to report a crime? And the Australian public are entitled to know what the morals, principles and ethics are of those who serve us as ministers of the Crown. Entitled to know.
Now, Bernard, I think that Jay has got a question for you, which, if that's the case, I'll get Hugh to ask.
Perfect. So Jay asks, was it worth it? What would you do differently for people going down the same path as you in the legal profession, and perhaps more widely as well?
Well, there's only one person I've ever just flatly refused to act for. That was Ivan Milat, but that was because one of our daughters was hitchhiking, and I couldn't, couldn't give a proper mind to it, and I was certain the police had botched the job anyway, and he hadn't been alone. But now I couldn't turn witness K away. I can't. I wouldn't forgive myself. You can't. As a lawyer, I'm not going to be scared. You can't be too scared. The approvals were there. In fact, there was no access to an administrative appeals tribunal. They have no public interest disclosure rights, those people. I could see an appalling morale issue. Someone rang me recently and said, Collaery, tell the truth. Kay isn't a whistleblower. No one knows who he is. He's never spoken a public word or asked for a public word. I said, indeed. He said, so tell the truth. He's the leader of a mutiny, wasn't he? I said, I can't answer that. I can't answer that. I did want to say earlier that it's a good agency when there are people like Witness K. I can't go further. but I would do much the same, although I would have shifted my brief and my records out of my country. You do know that I had to stay abroad after that. My team of Australian lawyers, we had been put at risk by this public raid that told the world we might act for a spook or maybe other spooks. I had young Aussie lawyer staff, and suddenly overnight, the Australian government had revealed the connection to my practice of witness K, and profoundly. And I stayed out of the country, and how many lawyers in my place will act again, for example, for a sovereign country? The new foreign interference laws have very cunningly made any activity that affects Australia's economic activities, no longer economic well-being, Australia activities, as potential sabotage and treason. So it's narrowed the scope of our capacity to act for countries in the Pacific, Kiribati, and I had a brief in Vanuatu on occasion, and matters like that. So yes, I do it again, but I would take protective measures for my staff, and I would tell them there's a possibility the Australian government might reveal the case, disclose the case, as it did in my case. We had arranged for there to be a confidential hearing at The Hague under very strict rules. We'd appointed eminent judges. It was to be heard in private. The whole thing was blown sky high while we were asleep in The Hague. And my public comments to the ABC, I got to stress, were after that in line with advice I took at very senior level and in line with the law as the High Court sees it. Australian public are entitled to know of executive misconduct. It can't be hidden.
Thank you, Bernard. Can I say I agree completely with that sentiment? And we were due to finish about a quarter of an hour ago. So I want to thank all of you who've received Voltaire Awards tonight. And of course, Duan Hussain, the Voltaire Human Rights Award to Dylan Alcott, and Bernard and Witness J for the Empty Chair Award. I would also like, on rounding off, to thank our volunteers and others who made all of this possible, especially Grace Girardi, Jessie Taylor, who's the former president of, immediate past president of Liberty Victoria, Julia Kretzenbacher, Andrew Rawson, Sally Ann Ra, Jill Rochelle, Hugh, who was the J for the day, and Thomas Kane. So thank you all, and let's keep this organisation going. So if you have the opportunity to donate, I hope that what you've heard tonight will make you realise that it's something that is seriously needed in this country right now. Thank you. Thank you all, and good night.